So, Roe v. Wade has been overturned, and Justice Clarence Thomas said other 14th Amendment rights could be next. But what does that even mean? What rights are included under the 14th Amendment? How did we get here? Let's discuss. First, let me thank the sponsor of this video, Factor. When I'm feeling stressed and overwhelmed, the last thing I want to do is cook. Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And my friends, this is not your grandma's TV dinner, okay? Factor's food is fresh and genuinely really tasty. Like the first time I took a bite of a Factor meal, I said, oh damn. I love that there's no prep and no mess to clean up with Factor meals, cause y'all, I am busy and I'm not particularly passionate about cooking. But I'm also trying to be better about caring for my body and my health, and Factor helps me do that. Factor meals arrive pre-prepared and ready to eat in 2 minutes. So I get to eat food that I know is fresh and healthy, but Factor also offers a really great variety with a rotating weekly menu of 25+ meal options. I loved this blackened salmon with smoked Gouda cauliflower grits and broccoli. I mean, come on. They really do not skimp on the flavor. Factor has become my go-to lunch or dinner solution when I'm juggling a million things throughout my day and don't have time to cook. They also have these protein-rich smoothies that are so handy when I need to head out the door, but I know I'll need to refuel before I get home. They have a variety of meal plans to choose from, but I personally appreciate that they don't skimp on the calories. Like, sorry honey, 250 calories does not a meal make, you know what I mean? I come from thick German farmers. I cannot survive on rabbit food, and Factor's meals are genuinely satisfying while also being tasty and convenient. Factor is now owned by HelloFresh, so with both brands I really enjoy the flexibility of being able to cook conveniently with HelloFresh or grab and go with Factor. Love this for me. Head to go.factor75.com/Leeja120 and use code Leeja120 to get $120 off Factor meals today. Okay, so let's start with the actual text of the 14th Amendment. It was ratified in 1868. What does this thing even say? Well, it's actually rather long, and in case you missed it, I kind of blew up on TikTok recently because I literally read the entire Constitution out loud on TikTok. And one of my videos on my US Constitution playlist is just me reading the entire 14th Amendment. So if you really want the whole thing read to you, go check it out there, where I'm also going to be going over other bite-sized snippets all about constitutional law. My handle is @LeejaTheLawyer. Shameless plug. Anyway, we're just going to focus on section 1 because that's the one that's causing all of these problems. It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Okay, so that last sentence, nor deny to any person within its jurisdiction the equal protection of the laws. That's where we get constitutional protections against laws that are written that specifically discriminate against a protected class, like women can't drive or something. That would be unconstitutional because of the Equal Protection Clause. That's an important clause, but it's not the one that we're primarily focusing on today. Instead, we're focusing on the sentence right before that, the Due Process Clause, which says, nor shall any state deprive any person of life, liberty, or property without due process of law. We've talked about this clause a lot on this channel, but there are two types of due process that the Supreme Court has found are encompassed by this clause. There is procedural due process, meaning that before someone's life, liberty, or property can be taken away, they are literally due process. They are due usually notice that this is happening and then a hearing of some sort so that they can be heard before a judge. Then there's substantive due process, which looks at whether a law passed by the state that deprives a citizen of something, whether that law has sufficient substantive justification or a good enough reason to deprive the citizen of whatever the law deprives them of. And the thing they're being deprived of, that either is something protected in the first 8 amendments of the Constitution, so like free speech or something, or a fundamental right not explicitly stated in the Constitution. Okay, so even narrower than the Due Process Clause when it comes to Roe and the other 14th Amendment rights that people are worried are now also at stake, we're talking specifically about substantive due process, fundamental rights that the 14th Amendment's Due Process Clause has been found to protect. And then even more specifically to that, so the clause is no state can deprive person of life, liberty, or property without due process. That doesn't say privacy at all. But through court precedent, which we'll talk about, the Supreme Court has found that there is a fundamental right to privacy implied by the idea of liberty within that clause. To be free, to have liberty, one deserves a certain amount of privacy. To determine whether something falls under the umbrella of liberty, the court looks at whether this is a right that is deeply rooted in our history and tradition and essential to this nation's scheme of ordered liberty. Which is why in both the Roe decision and the Dobbs decision, the one that just overturned overturned Roe, the court spends substantial amounts of time looking at history to determine whether the right to an abortion is rooted in our history and tradition and required for ordered liberty, and thus protected under the 14th Amendment. So state laws that infringe on certain aspects of privacy must have a substantive justification for that invasion of privacy if it infringes on a liberty protected under the Due Process Clause, which is one that is deeply rooted in our history and tradition and essential to ordered liberty. Okay? It's not that the state can't interfere at all in privacy, just that there needs to be a substantive justification when that right is fundamental to ordered liberty, which privacy is. And with Roe, the 1973 Supreme Court determined that the right to an abortion before fetal movement was deeply rooted in our history and tradition, and they did a wide examination of human history and looked at the general acceptance societally of abortion prior to the 1850s when abortion started becoming outlawed in the states. I did a deep dive on Roe and also on 1850s abortion laws. You can check that out. I'll link it up here somewhere. And the court found that there was no substantive justification for a state to interfere with a person's private right to choose with their doctors whether or not to undergo an abortion before viability of the fetus. Once the fetus is viable, that's when the Supreme Court determined that the state had substantive justification for interfering in the privacy of choosing whether to procreate, because then the state has an interest in the life of the fetus because it could technically exist outside of the womb. So that's where the 22 weeks comes from. That's generally considered viability, okay? But the 1973 Supreme Court didn't just come up with this idea that privacy is protected in what are called the penumbras of the Constitution, meaning the shadows of the Constitution, meaning a right that's implied and read into the Constitution even though it's not explicitly stated in the Constitution. They didn't just come up with this during Roe v. Wade. So the right to privacy is a penumbra of the 14th Amendment, but the Roe court didn't come up with that on their own. It was based on precedent. And since the Roe court, other Supreme Court decisions have also been based on that 14th Amendment right to privacy, which is why so many people are a bit freaked out about whether this decision will unravel the other rights that the implied right to privacy protects under the 14th Amendment. I hope that makes sense. Let's look at the cases that have established other rights under the 14th Amendment right to privacy. I'm going to go chronologically so that you can kind of see how these cases all build on top of each other. Our earliest case is Skinner v. Oklahoma from 1942. This case occurred before a more robust privacy protection under the 14th Amendment had been recognized, so it doesn't explicitly say that the Due Process Clause was violated. It does, however, establish that the right to marriage and procreation are the basic civil rights of man. You see, this court case was all about the Oklahoma Habitual Criminal Sterilization Act. That's right, in Oklahoma and probably elsewhere prior to 1942, if you were convicted 2 or more times of felonies involving moral turpitude, the state had the right to forcibly sterilize you. But there was an exception. The act did not apply to embezzlement or political offenses. Like, clearly if you're criminalizing robbery but not white-collar businessy crimes like embezzlement, it's clear who these laws are meant to criminalize. Not rich people. So this law was specifically targeting people who, like Skinner, the guy who was convicted, stole chickens out of a chicken coop a few times. But not the guy who embezzled his company out of thousands and thousands of dollars. They were fine. And the Supreme Court said that this was clearly a violation of the 14th Amendment's Equal Protection Clause because it could clearly be used to invidiously prevent the procreation of certain people, which is called eugenics. And yikes. You know? So even though in this case the court didn't fully get to the idea that the 14th Amendment's Due Process Clause also protects the penumbras of the Bill of Rights, and in those penumbras is the right to privacy, etc., they listed marriage and procreation as basic civil rights of man, even though they're not listed anywhere in the Constitution. So it was an important early step and worth mentioning. Next is Griswold v. Connecticut. This case was decided by the Supreme Court in 1965. The named plaintiff was Estelle Griswold, the executive director of Planned Parenthood in Connecticut, a pretty badass lady who was an activist, and as part of her role at Planned Parenthood, she organized border runs to New York and Rhode Island for women seeking birth control. You see, Connecticut had outlawed birth control in 1879. Reminder that this was 1965, so it was a law written even before we had modern birth control and had banned contraception of any kind. The other plaintiff was named Buxton. He was the medical director for a Planned Parenthood center in New Haven that they opened in 1961 to offer specifically married people advice on the means of preventing conception. This was, of course, illegal under the 1879 law, so they both were arrested and fined $100. They knew that this was illegal when they began doing it. In fact, the center that they opened operated a total of 9 days before being shut down. They did this on purpose in order to be given a reason to challenge the old law. This is called cause lawyering. It's purposely breaking a law so you can then challenge its constitutionality in court. Basically, you have to have been prosecuted under a law generally before you can then challenge it. You can't just go to court and say, I think this is a bad law and I think it should go away, unless you've personally been prosecuted. prosecuted under the law. Anyway, so they're arrested and they argue that the law infringes the 14th Amendment, and the Supreme Court agreed. They first looked to the First Amendment to prove that there are penumbras or peripheral rights that are protected by the Bill of Rights, even if it's not explicit. The First Amendment protects the right to learn and the right to associate with groups and the right to read, etc. Because infringing someone's right to learn in a foreign language, for example, or join a communist party, necessarily restricts their free speech and therefore violates the First Amendment. And because there are penumbras there are many penumbras in these amendments, and in fact, they are clear that a right to privacy is a penumbra in many of the amendments, including freedom of association under the First Amendment, freedom from having to quarter soldiers inside your house protected by the Third Amendment, freedom from unreasonable searches and seizures protected by the Fourth Amendment, and freedom from self-incrimination in the Fifth Amendment. And then the Ninth Amendment says that the list of rights is not complete. Just because it's not listed there doesn't mean that the right doesn't exist. So the court concludes the right to privacy in the home and of the person is clear, and what's more private than the marriage relationship and the marital bedroom? Therefore, government interference into the marital bedroom is clearly a violation of privacy protected by the penumbras of the Bill of Rights. So, in making its decision, the court determined that the right for married couples to use contraception is protected under the 14th Amendment's Due Process Clause. That was Griswold. Next, we have Loving v. Virginia, decided in 1967. That case involved a Virginia statute that banned interracial marriage. Mildred Jeter and Richard Loving were married in 1958 in Washington, D.C., where interracial marriages were legal, and they then moved to Virginia, which was one of 16 states at the time where interracial marriages were outlawed and criminalized. The couple were quickly indicted and sentenced to a year in jail, which the judge agreed to suspend if they left the state, which they did. The judge stated, and I quote, and sorry, this is going to be offensive, "Almighty God created the races white, black, yellow, Malay, and red, and he placed them on separate continents. And, but for the interference with his arrangement, there would be no cause for such marriage. The fact that he separated the races shows that he did not intend for the races to mix." Which, first of all, I've never done research into how judges justified their clear mix of church and state back when they were allowed to say shit like that, but I'd be interested to know how they justified saying that shit. But also, like, who's the reason why blacks and whites are mixing? Black people generally didn't come here for fun originally. Anyway, so the Lovings appealed their conviction all the way up to the Supreme Court, and the court found that the law violated the Equal Protection Clause because it discriminated based on race, with no rational reason provided by the state as to why that was necessary. And they said it was also a violation of the 14th Amendment's Due Process Clause because, as Skinner v. Oklahoma said, marriage is one of the basic civil rights of man. And even Griswold v. Connecticut upheld the fundamental right of the privacy of marriage and the marital bedroom. The court said that to deny this fundamental freedom on so unsupportable a basis as the racial classifications embodied in these statutes, classifications so directly subversive to the principle of equality at the heart of the 14th Amendment, is surely to deprive all the state's citizens of liberty without due process of law. Which is, of course, interesting because that was 1967 and it wasn't until 2015 that the Supreme Court extended that to same-sex marriage, but we'll get there. All right, and next we have Eisenstadt v. Baird in 1971, 6 years after the court decided in Griswold v. Connecticut that married couples had a fundamental right to contraception. In Eisenstadt v. Baird, the court decided that contraception would become a fundamental right for single people as well. In that case, William Baird was convicted under a Massachusetts law that said whoever gives away any drug, medicine, instrument, or article whatever for the prevention of conception shall be imprisoned for up to 5 years unless that person is registered as a physician or a pharmacist administering contraception to a married couple. Baird gave a lecture at Boston University about contraception and then gave away vaginal foam, a form of contraception, to a single woman at the end of his lecture. He appealed his conviction on constitutionality grounds, and it made its way all the way up to the Supreme Court. And the court found for Baird. They said that Griswold found that the 14th Amendment's substantive due process protections extended to contraception, but that case only applied to married couples. However, looking to the Equal Protection Clause of the 14th Amendment, which says no state shall deny to any person equal protection of the laws, the state law has to be rationally related to a valid public purpose in order to be allowed to discriminate against married versus unmarried people. And the court said that there's no rational reason why the state needs to discriminate who gets contraception based on marriage status. The state claimed that the statute was meant to protect chastity and purity and deter from premarital sex, but the court was like, no, it's not. Because the court said Massachusetts did allow for the distribution of condoms for the prevention of disease. So like their prohibition on other contraception didn't make much of a difference regarding the prevention of fornication. Plus the law punished distributors more heavily than the actual people supposedly doing the fornicating. So the court said, yes, Griswold established contraception to be a fundamental right under the 14th Amendment's privacy protections. And yes, this is a violation of the Equal Protection Clause because you're not equally applying your laws to people and you're denying a specific class of people their fundamental rights. And with that, protection to all people for access to contraception was achieved. Shortly thereafter, in 1973, the court decided in Roe v. Wade that this right to privacy extends to procreation and the decision not to procreate. I've already made multiple videos breaking down the intricacies of Roe v. Wade. Go check them out. I'll link them up here. Okay, moving ahead in time, we have Planned Parenthood v. Casey in 1992. Casey isn't a case about a different 14th Amendment right, but I wanted to touch on it briefly because it's an important case that you'll likely hear come up often because it's the main case that altered the Roe decision until now. In Casey, the court created the undue burden standard, which said that, okay, a state can make regulations about abortion before 22 weeks, before viability, but only if that regulation does not create an undue burden to the person seeking an abortion. And this standard has then been stretched over the years because a slew of states started passing laws like 24-hour waiting periods, consent requirements from parents or the fathers, requiring patients to hear the heartbeat, requiring patients to receive reading materials about babies and birth and other non-medically necessary information, etc. However, in that case, in Casey, the court also firmly reasserted the 14th Amendment's protection of privacy in personal decisions relating to marriage, procreation, contraception, family relationships, child rearing, and education. So again, we've had the court over and over and over for decades confirm these protections exist under the 14th Amendment. And then there's Lawrence v. Texas in 2003, which revolved around a Texas law that outlawed gay sex. A couple were caught in the act by a police officer and were arrested and convicted of deviant sexual intercourse. And they then appealed the case up to the Supreme Court, which confirmed, based on Casey, based on Griswold, based on Eisenstadt v. Baird, based on Roe v. Wade, that the court has over and over and over again confirmed that privacy and personal decisions related to sex and procreation is a fundamental right protected under the 14th Amendment's Due Process Clause. And therefore, any law outlawing gay sex is unconstitutional. And then finally, we get to Obergefell v. Hodges in 2015, which legalized same-sex marriage. I made a whole video all about this case about a year and a half ago, in which I predicted that marriage equality could be in danger because at that time, Justices Thomas and Alito had recently come out with a random letter being like, hey, bring up some cases to us to give us the opportunity to overturn same-sex marriage. You can go watch that video for an in-depth rundown on Obergefell v. Hodges, but basically the case is a combination of many challenges to various state laws banning same-sex marriage on the basis that the bans violate their right to privacy in certain personal choices central to individual dignity and autonomy, including intimate choices that define personal identity and beliefs, as established by years of Supreme Court precedent under the 14th Amendment's Due Process Clause. They again cite to Eisenstadt and Griswold and Loving and Skinner to support the conclusion that marriage is a fundamental right protected under the 14th Amendment's Due Process Clause and should be extended to same-sex couples. I think the hang-up that's important to note in understanding why, for example, it took 48 years for the court to connect the dots between interracial marriage being protected and same-sex marriage being protected is the fact that if a state is able to show a rationally related state interest in why it's passing these laws against same-sex marriage, then it's fine. They can do that. They can discriminate. These laws are only getting overturned where the Supreme Court is saying these laws violate a fundamental right and the state doesn't have a good reason for it. And because of prejudices and biases and society at large being bad and dumb, it wasn't really difficult to come up with a good reason for barring same-sex marriage because the state could just say, I don't know, furtherance of the human race and protecting the sanctity of marriage and conforming activity to what society deems acceptable. And the court would be like, yep, this type of denial of fundamental rights is fine. Additionally, the court likes to delve into history to justify what it determines to be protected by the liberty, what is a fundamental right under the 14th Amendment. Because, like I said at the beginning, to figure out what liberty is, the court looks at what is deeply rooted in our history and tradition. And in that historical analysis, it's really easy to cherry pick what parts of history support your claims. So you can say, we've clearly outlawed gay marriage for a really long time, therefore it's deeply rooted in our history that gay marriage isn't a protected liberty. Or you could say there is a clear and deeply rooted history of the importance of marriage in society, but we've also grown as a society to be more accepting and understanding of the LGBTQ population, and so this fundamental right to marriage that is clearly a deeply rooted liberty should also be extended to them. So the combo of cherry-picking history and biases and prejudice in society mean that despite precedent that seems clearly to say that marriage is a private right protected under the 14th Amendment, it takes 48 years after Loving v. Virginia for that fundamental right to be extended to gay marriage. And this is just one example. Okay, that was a lot. As a review, we've gone over cases that protect a wide range of rights under the privacy protections found in the 14th Amendment. And those rights are a right in child rearing and education, which I didn't get to specific cases on because they're slightly less relevant, but just know there's a privacy right to how you raise and educate your children, plus the rights to marriage, procreation, and contraception. And of course, because Roe is based on the 14th Amendment's due process protection of privacy as well, people are worried that all these other rights are also in jeopardy. I've heard floating around TikTok that the separate but equal doctrine upheld by Plessy v. Ferguson, a case which I've already made a video on, go check it out, which allowed for Jim Crow laws, and Brown v. Board of Education, which overturned separate but equal and required desegregation of public schools, that those could all also be at risk as well because of the overturning of Roe. Those cases, however, were based on the Equal Protection Clause, which is of course related to the Due Process Clause, but in Brown v. Board of Education, which explicitly overturned Plessy v. Ferguson, the court explicitly said that they would not decide the case on the Due Process Clause of the 14th Amendment. So it would be a stretch for a case to come up to the Supreme Court now and argue that because the privacy protections in Roe have been overturned, then Brown v. Board of Education should also go. Seen a lot of people, especially on TikTok, really sensationalizing this to the point of making people think that the Supreme Court is going to order tomorrow that everything go back to like Jim Crow era. That's simply not a realistic interpretation of what's happening. And while we should be ever vigilant, let's not be fearmongers, shall we? And I'll also note that both the majority opinion in Dobbs, the case that just overturned Roe v. Wade, as well as Brett Kavanaugh's concurring opinion, explicitly state that because Roe involves a right that considers the critical moral question of ending potential life, it is different than the other privacy rights, so overturning Roe does not undermine those rights in any way. It's just old Clarence Thomas that says in his concurring opinion that the other rights are also now questionable. So it's unclear whether the Supreme Court would have the votes necessary to overturn others of these 14th Amendment due process rights to privacy. Though both Thomas and Alito have indicated in the past, like I said, that they'd be interested in revisiting the gay marriage question. Again, be ever vigilant, but not sensationalist. It's still a possibility, but it's not happening tomorrow. You know what I mean? The law and legal precedent moves at a glacial pace, which can be infuriating, but can also be reassuring to some degree. The things to be more concerned about in the next Supreme Court term are affirmative action and election laws, both of which they're hearing cases on, but that's a topic for another day. All right, my friends, that was a lot, but I wanted to do a brief overview of these cases to give you an idea of how this specific area of constitutional law has been shaped over the last century and the actual context of Roe v. Wade's overturning in that lineup of precedent. Mainly to quell fears that other rights are going to be swiftly stripped away. Your fear and anxiety is entirely valid, but there's been some sensationalizing that I didn't appreciate because it just adds unnecessary fuel to the flame of all the division and uncertainty in this country right now. Let me know how you're feeling in the comments below. Also, let me know if you have any questions because this was a lot. Thanks again to my partner on today's video, Factor. When I'm stressed, I don't want to cook, so I let Factor cook for me, and it's awesome. Head to go.factor75.com/Leeja120 and use code Leeja120 to get $120 off Factor meals today. If you liked this video, you'll probably also like my video all about marriage equality and Obergefell v. Hodges. Thanks so much for watching. Have a good day. Bye-bye.